Thank you for being here. We're just going to go through a formal opening statement and then we'll invite you to make some opening remarks. So, I declare open this second hearing of the Senate Economics Legislation Committee inquiry into Tax Laws Amendments Public Benefits Test Bill 2010. The bill was referred to the Senate Economics Legislation Committee for inquiry on 13th of May 2010. The committee is due to report on the 31st of August 2010. These are public proceedings, although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. I also emphasise that the terms of reference of this inquiry are limited to the examination of the provisions of the Tax Laws Amendment Public Benefit Test Bill 2010. The committee acknowledges there has been public commentary concerning particular organisations. However, the operation of individual organisations is not within the terms of reference of this committee, and the committee does not have the authority to deliberate on such matters because they are not relevant to the terms of this inquiry. I ask all members of the committee and witnesses to ensure that questions and comments are relevant to the terms of reference of the inquiry. A copy of the bill is available from the Secretariat if you require guidance in this regard. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. I remind members of the committee that the Senate has resolved that departmental officers shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions to superior officers or to a minister. This resolution prohibits only asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. A witness called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphone to assist Hansard record the proceedings. So I welcome Mr. Lyle Shelton and Mr. Ben Williams of the Australian Christian Lobby. Would you gentlemen like to make an opening statement?
Yes, thanks very much, Mr. Chairman, and thanks very much to the committee for the opportunity to be here today. We really do appreciate it. Mr. Chairman, our remarks will be very brief. We'll just make a brief opening statement to augment that which we've said in our submissions, and we don't intend to take the committee's time, although we're happy to answer questions. For the record, Mr. Chairman, I'd like to state that the Australian Christian Lobby is a not-for-profit company limited by guarantee. ACL pays company tax, fringe benefits tax and GST. ACL does not benefit from any tax concessions. Our supporters cannot receive tax deductions for their donations, unlike some other groups which lobby into the Parliament. And I just wanted to make that statement just so that the committee is aware that we have no material interest in this, although many of our supporters and those who support our organisation work in the religious charitable sector, doing good in the community, and they would obviously be affected by a potential impost that might come as a result of this amendment. It is often said that hard cases make bad law. I think it could equally be said that the use of extreme examples also could lead to the making of bad law. The Church of Scientology cult's alleged criminal activities, according to lawyers who have made submissions to this inquiry, are reason enough for that group's tax-exempt status to be revoked under existing law. The Agape cult has already had its tax-exempt status revoked under our existing law. There is no need for a catch-all law to be enacted without proper debate and consideration of the consequences, intended or otherwise, seemingly all because of the activities of a couple of friends groups. Churches and Christian charities use tax-exempt status to maximise their ability to provide services to the poor, the mentally ill, the disadvantaged in our community. It is well known that the public benefit test in the United Kingdom was not needed in order for the Church of Scientology to be denied tax-exempt status there, despite media reporting as late as yesterday reinforcing a contrary perception. Australia's charitable sector does not need yet another layer of bureaucracy imposed on it because of the bizarre and allegedly criminal behaviour of cults. Just as a public benefits test was not needed in the UK to deny tax-exempt status to groups like the Church of Scientology, neither is it needed here. A public benefits test for charities sounds well and good, but the reality is that tax-exempt status is not available under existing laws unless rigorous requirements are met. The lack of consultation surrounding this bill is a major concern to the sector. A public benefits test for charities sounds wonderful, and arguing against it almost sounds like arguing against motherhood. But the idea that Australia needs one implies that somehow charities and religious groups are receiving tax concessions now without adequate scrutiny. This is simply not the case. If there was no remedy for the anomalies in tax exemption status Senator Xenophon has rightly identified, a case could be made for such a law as that which is before the Senate now. But the reality is that remedies exist here in Australia, just like they did in the UK, to deny the Church of Scientology tax-exempt status long before a public benefits test was introduced there. However, ACL submits that the serious alleged abuses Senator Xenophon has rightly given profile to go way beyond the rorting of tax laws. Elliot Ness got Al Capone not because he was a murderous gangster, but because he could prove that he cheated on his taxes. It is disappointing that it seems that the Senate's Economics Legislation Committee is the only recourse available to the Senator to raise valid concerns about the alleged abuse of people at the hands of a strange cult. As former Scientologist James Anderson was reported to have told this committee yesterday, quote, "There are a large number of extremely worthwhile charitable organisations and they do fantastic work. And I don't think that they should be punished because of the allegations levelled at a particular organisation of which I was a member for 25 years. ACL could not agree more with that. Thanks very much, Mr Chairman.
Thank you. I might just ask you a question following on from what you've said. You've focused very much on Scientology and, denial of their tax-deductible status, but establishing a public benefits test and a charities commission would do far more than just deal with an organisation which might have undesirable practices. There are other issues. It seems that a lot of money passes through the hands of charities, and yet there's no public accountability, and there's a lack of transparency about their operations. And as was done yesterday, we looked at the websites of the Charities Commission in New Zealand and in the United Kingdom, and there's a great deal of detail provided on those websites about various charities openly accessible to the public. And I personally think that's probably a public good, that that kind of information is available, and I just wondered if you'd like to comment on that. Is there a need for greater transparency in the operation of charities and greater public accountability of their expenditure?
Look, Mr Chairman, obviously charities operate under various legal structures. Some operate as companies limited by guarantee or as incorporated associations or the like. And we have Australian law to deal with that. I would think that our existing laws do provide opportunity for scrutiny. Obviously audit processes, especially the larger charities, go through rigorous audit processes by law. Perhaps there could be opportunities for greater disclosure, perhaps greater disclosure on websites. But all of that could be looked at. But I just think that to impose a public benefit or to imply that somehow charities are getting some sort of a public benefit without proper scrutiny. I don't think that's the case just because there's been a couple of anomalies, and there is a widespread perception out in the community, rightly or wrongly, that this has been motivated largely by the anomalies that have been, as I say, rightly unearthed in some organisations. But I think it would be unfair for the rest of the sector to be, tarred with a similar brush.